in the court now where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial we pay the price.
Hey, yo, folks. Welcome. Welcome. Oh, it is 9:30 a.m. Eastern Time. It is 3:30 Swedish time. And somehow the weather decided to prepare me for Texas, because it's currently 88 degrees Fahrenheit out, and it's warm as hell. Oh, sorry. Hello, folks. I saw No Cursan here earlier, and Gwendolyn, and Stuff, and Sir Frank Otter, and Berta, and Goddess, and Iron Rabbit, and Breaking It Down with B. Currently filling the chat with noise. Good on you. Yeah, as far as I know, I have all the motions. But I want to focus immediately on, when you're winning the court of public opinion, when the state wants you silenced. The prosecution have filed a motion to restrict the attorneys from extrajudicial statements. They want to restrict the defense attorney's rights to say anything, anywhere. That is, first of all, it's insane. But it's, as I said, it's very telling. The prosecution are realizing they are losing the public opinion. I mean, you've seen Doug here on my show. He has been on other shows. You have seen Attorney Charles on shows. You have, and it's an excellent timing for it as well, because judges aren't immune to news. They are supposed to be, but they're not. Few are. I will see if I can find it. An example. This is, it's almost 10 years ago. I had negotiations of a factory closing. And they wanted me to stay very, very silent, because it would be bad publicity and bad for the negotiations and everything. And they kind of put too much focus on it. So I wrote an article in Sweden's biggest newspapers with this as a picture. These are some of the people who were let go. This was a planned photo. First of all, if you know, there's a classic photo from New York from the 1920s, I think, workers on a skyscraper. And to the left of the workers, you might see there's a black and yellow pole, and then behind it, it is a sign in the shape of well, you see it. So don't piss off. I don't know why people in power do this. Try to silence people. Now, yeah. Yeah. So let's just say, after that article, the that company was willing to negotiate faster for better terms. And I do believe that the attorneys in the Young Thug case is of a similar mindset. Just don't, because it's a really, really bad idea. For instance, you've seen Doug. He's soft-spoken. He is highly intelligent. He doesn't want to use too many words. And, well, this is what he wrote on the Twitters. So he writes, I will not stop speaking out publicly for the rights of my clients. Justice demands no less. The state's motion to silence me has no merit, and I fully expect the court to find as such. People in glass houses should not throw stones. Doug. Oh, Doug, you are a gem. You are a gem. Oops. There. Hello, Cat. Hello, Cat. I want to invite Cat. I'm sending Cat an invite. Where are you? There you are. There were two filed last night at 11. Let's see, what do I have here? I have the state's motion to restrict. That's the one I'm going through. Motion for reconsideration, Copeland. Exclude victim bad character evidence. State's motion. Renewed bond. Nichols' motion for mistrial and objection. Stilwell's motion for fair trial. Kendrick motion for mistrial. Yeah, I have a few. But no, these are all from July 23. Now, if you are invited, so if I miss anyone, feel free. Yeah, it is. I agree, Kat. It is appalling that the state tries to do this. But let's see what they have to say. Because if this is the level the low level they are going to, this will be hopefully, because we will hear about these motions on Tuesday. They will meet in court for a hearing on Tuesday. It might get heated, but I do believe Judge Whitaker can handle it. But here it is. The state wanting to silence the defense. In the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams et al. State's motion to restrict extrajudicial statements comes now. The State of Georgia and moves this honorable court to instruct the defense to refrain from making further extrajudicial statements about this case moving forward. It would be my answer, but I would write it in legal speak. Georgia Rule of Professional Conduct, Rule 3.6, prohibits lawyers participating in litigation from making extrajudicial statements a reasonable person would, quote, believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. They have some nerve. They have some nerve. And these are the footnotes is just, yeah. I'm going to put. Hold on, copy. Let's see what that actually says. Dun, dun, dun. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that a person would reasonably believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Yeah, reasonably. Likelihood. Yeah, go screw yourself. A relevant factor in determining prejudice is the nature of the proceeding involved. With criminal jury trials being the most sensitive to extrajudicial speech, the character, credibility, reputation, of a party, and quote, any opinion as to the guilt or innocence of a defendant are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. How many press conferences and press releases did Fannie Willis conduct herself in before the trial started? A ton. So, no. This isn't going anywhere because just no. And looking at every time a prosecutor has a press conference, every time a prosecutor shares with the journalists in the papers, I mean, Fannie Willis, Love, Hilton, you need to watch yourselves in the mirror. Yeah. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendant Williams' counsel, attorney Brian Steele and Keith Adams, defendant Kennedy's counsel, attorney Doug Weinstein, and defendant Stilwell's counsel, attorney Max Charge, has all make extrajudicial statements to the media explicitly discussing this case in violation of Rule 3.6. If they only state we believe our clients are innocent, if the comments about this case is only about evidence the prosecution have moved in, how would that be prejudicial towards the state unless the state themselves know their case is shit? Oh, wow. Oh, wow. Thank you, John Commune, for gifting 5 memberships. Thank you so much. It went to Nokursan, A.J. Taylor, Goddess, Stala Starbright, and Sherin Alexander. Hey, you now have access to all my members-only content. Congratulations. There's a ton of it. John Commune says, I wonder if the defense lawyer speaking out is starting to hurt Fanny's campaign and this is just damage control. Yeah. And not only Fannie Willis' election campaign, you have a big election coming out, and for most people, for many people who are already deeply involved in this, they know that Fannie Willis meeting with the vice president and everything around that. So not just this case, but yeah, it has some bearing. It has some bearing because what happens in court now, or happened the past month and a half in court, reflects back to Fannie Willis, elected district attorney. Let's continue. The extrajudicial statements have included, among other things, interviews and statements to the Associated Press. 4 of those interviews has been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's views and opinions about the case itself. Opposing counsel, the now former judge, the jury, the outcome, and the guilt or innocence of specific defendants. Oh, boo-hoo. Boo-hoo. Can you whine more? Pursuant to OCGA, courts have the power to control in the furtherance of justice the conduct of its officers and all other persons connected with the judicial proceeding before it in every matter appertaining thereto. The state thus moves this honorable court to instruct the defense from refrain from making extrajudicial statements about this case moving forward. This is stupid because in order to have this have bearing, you also have to see the prosecution's conduct throughout this case. And hypocrisy, anyone? Hypocrisy? And here, Exhibit A. Below, please find Brian Steele's statements regarding the recusal order. Jeffrey Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would have received the constitutional guarantees of a fair trial, with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Mr. Williams' case. We look forward to proceed with a trial judge who will fairly and faithfully follow the law. Now, let's see here if I find it fast. I do. Just so you know, they took that from Thug Daily. They took that from Thug Daily. They just cropped out Thug Daily. Ha! Oh. Yeah. Next exhibit. Exclusive Young Thug's attorney. I don't know which channel this is. It's from Infamous Sylvia. Infamous Sylvia is entered as evidence in a motion. Ha! Or as an exhibit. Infamous Sylvia, you're an exhibit for the state. Oh yeah, I wish they would have named me in this. That would have been amazing. Exhibit C. The Associated Press reached out to Glanville and to a lawyer. A spokesperson from Willis' office declined to comment. And you see here, the Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. A spokesperson for Willis' office declined to comment. Why would a spokesperson for Willis' office decline to comment if they reached out to Glanville and a defense attorney? Yeah, this is just stupid. Exhibit D. Attorney Doug Weinstein discusses live with journalist Megan Cuniff. So, Megan Cuniff got some some exposure. Exhibit D. Again, Megan interviews defense attorney Max Schott. Exhibit F. The debrief interview with attorney Doug Weinstein. Who's that? From the channel I'm Not a Lawyer, But. There I get. And I'm so disappointed I'm not in here. I'm so disappointed. I'm actually bummed out. I mean, I've been working hard as hell, and I'm not mentioned. But so that is the first one, and it's stupid. It is so stupid that the defense attorney in Georgia not being allowed to be interviewed and speak on the case. That's plain stupid. Plain stupid. And where was I? Oh. Let's see here. Let's go to this motion. This is a fun one. Dun, dun, dun. This is the state's motion to exclude victim character evidence. This is a fun one. Filed yesterday at 4:32 p.m. State of Georgia. Introduction. The state believes the defendants in the above-styled case may attempt to improperly place the character of the deceased victim, Mr. Donovan Thomas Jr., in issue at the trial of this case. For the reasons stated below, the state moves this court to prohibit any attempt by defendants to elicit and introduce improper character evidence as prohibited by OCGA. They had Donovan Thomas' dad on the stand talking, and at that time I said about Donovan Thomas Sr., I understand him. I completely understand why he's there, why he's testifying the way he does. But it opens up for cross-examination, which it did. And it opens up for them, if necessary, to call him back. Now, I don't think they have him on the exhibit list, the defense. But this, yeah, I mean, the prosecution opened that door for character evidence. This is one of the things that I believe that the new judge, Judge Whittaker, should revisit Judge Glanville's decision to allow the state's character witness or character testimony. And because this is just, Judge, we can do it. We don't want them to do it, which is never the intent of a law. And then continue. Defendants Diamante Kendrick and Shannon Stillwell are charged in count 2 with the ending of Donovan Thomas Jr., overt act 16 to 20, of count 1 conspiracy, blah, 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 blah. The defendants have pled not guilty to both count 1 and count 2 and have never raised or asserted any claim of self-defense. No, they don't have to. Arguments and citation of authority. And here they state Walker v. State. Walker v. State was referenced by the defense at the time against some of the character testimony the state wanted to bring in. Judge Glanville. Okay. I'll allow it. So now, say Judge Whittaker says, no, this type of character testimony and evidence is not allowed. What do you have then? Then you have Judge Glanville ruling on the same issue, using the same statute in one way, and Judge Whittaker doing a 180. That's an appellate issue. A really strong one at that as well, in my opinion. A victim's character may only be admitted if there exists some factual nexus to the conclusion for which it's being offered. It's impermissible to establish such a nexus through sheer speculation. I mean, this is the state moving in this movement. It's breathtakingly stupid at this point. Because they want to hinder the defense from doing what they did. No factual nexus to admission of victim's character. The character of Donovan Thomas Jr. is, quote, irrelevant and inadmissible in this trial because there exists no factual nexus for introducing any evidence pertaining to his character. The state brought in several witnesses, well, at least Donovan Thomas Sr., as a character witness. And I need to sneeze, sorry. Sorry, folks, I didn't have time to press the mute button. Furthermore, any evidence of victims' violent characters is irrelevant because no defendant has claimed self-defense. Finally, even if the court were to find a relevant purpose for victim character evidence, it could only permit admission through reputation and opinion testimony, not specific acts. Adrian Love. You hypocrite, Adrian Love. You absolute hypocrite. I mean, seriously. Thank you for all the bless you. Thank you. Now, what else do we have here to go through? Dun, dun, dun. Let's bring up this one now. Renew motion for bond and brief in support of pre-verdict bond. This is Attorney Steele. Let's get a first taste on Mr. Steele's ability to write a motion. Comes now, defendant Jeffrey Williams, by and through undersigned counsel, and hereby files his renewed motion for bond and brief in support of pre-verdict bond in the above reference case. In support of this renewed motion for bond and brief, Mr. Williams shows the below. In the great state of Georgia, unlike other states, for purposes of pre-trial bar analysis, the presumption of innocence remains with the person accused of an offense, even a capital offense, from arrest and even during trial. That means, prior to and during trial, courts view the criminally accused to be innocent of the charges waged against him or her. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecution proves guilt beyond a reasonable doubt. Thus, granting of a reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. In order to protect our firm foundational belief that the accused is presumed to be innocent prior to a finding of guilt beyond a reasonable doubt, the prosecution alone has the burden of persuasion in convincing this honorable court that there are no set of conditions or circumstances that can be ordered to permit Mr. Williams' pretrial release on bond. This requires the prosecution to carry the burden of proving by preponderance of the evidence that this honorable court must deny Mr. Williams' motion for bail outright rather than set bond with conditions of same in order to ensure Mr. Williams' presence in court and to protect the community. It is so significant to deny Mr. Williams' pre-verdict bond that the Honorable Supreme Court of Georgia requires this honorable court to specifically explain why no bond could be set so our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. When considering pre-verdict bond, alleged guilt is extraneous, is completely irrelevant and not considered for the pre-verdict bond analysis, as supposed guilt has no place in the bail proceeding since Mr. Williams is presumed innocent. You see here the difference between Prosecutor Love. Every sentence here has backup in law and case law and statute. Everyone. So far. This is what happens when you have case law on your side. You are not scared to reference it. Our highest court explained that in a bond hearing, Mr. Williams bears the initial burden of producing evidence that he would 1. Not pose a significant risk to flee the jurisdiction and would return to court when required. 2. Not be a significant threat to or danger to the community or to any person or property in the community. 3. Not be a significant risk to commit a felony while on bond. And 4. Not be a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. And here comes Mr. Steele's arguments. Mr. Williams is not a flight risk. To meet this burden, Mr. Williams must first present evidence showing his roots in the community, which would include the length and character of residence in the community, employment status, and past history of responding to legal process. Mr. Williams was born and raised in Jonesboro South section of Atlanta, Georgia. Since birth in August 1991, Mr. Williams has maintained residence in Atlanta, Georgia. Although Mr. Williams has traveled the globe, has performed his music and artistry in every continent, save Antarctica, he always returns to his homes in the Atlanta, Georgia area. In fact, days before the return of the original indictment and the arrest of Mr. Williams returned to Atlanta, Georgia from the country of Norway. Hey! He was at my neighbor. Mr. Williams is one of 11 children, and he is the father of 6 children, ages 16, 13, 12, 11, 9, and 9. All of Mr. Williams' family lives in the Atlanta, Georgia area, including his parents. There is not many among us who have stronger roots in our community than Mr. Williams. Mr. Williams has been working since he was 6. At age 14, he was recognized and began performing his music for audiences. As a teenager, he had a manager, and within a few years, Mr. Williams was signed by Atlantic Records and was paid $1 million. Mr. Williams is currently gainfully employed, tirelessly works at his artistry and other lawful business ventures that include clothing lines, modeling, owner of a successful record label, and various investments. Mr. Williams has demonstrated a strong history of lawful employment. Mr. Williams has appeared in courts in the past, represented by undersigned counsel Brian Steele, for approximately a decade, to wit, Mr. Williams' entire adult life. Mr. Williams has never missed nor been late for a court appearance. Mr. Williams has a history of responding to the legal process. Undersigned counsel is in possession of Mr. Williams' passport and has permission to surrender this passport as directed by this honorable court for purposes of bond. Furthermore, when a bonding company writes a bond for the criminally accused, that company takes a financial risk in ensuring the criminally accused presence in court. In the case at bar, Free At Last Bonding Company has agreed to write a bond set by this honorable court, and the representatives of Free At Last Bonding Company are motivated to keep track of Mr. Williams and prevent any possible flight. Mr. Williams intends to present witnesses to testify at the renewed bond hearing. Specifically, Mr. Williams' parents, managers, members of his record label, childhood friends, business associates, and the like will be present in court to testify and or show support for the granting of pre-verdict bond for Mr. Williams. Here's a thing I want to just members of his record label, business associates. If the state's case is that Mr. Williams have conducted and is conducting things in furtherance of the criminal street gang, why is not the record label on trial? They paid him $1 million. The prosecution have moved in lyrics and videos as evidence. Lyrics and videos produced by his record label, promoted by his record label. Now, why isn't people in the record label on trial? Yeah, good luck with that. Record labels have some of the absolute roughest and nastiest lawyers around. The prosecution will not go after record labels. That's a self-ending mission. Number 2, Mr. Williams is not a significant threat to the community or to any person or property in the community. Mr. Williams has taken the initiative to secure the commitment of full town off-duty sworn law enforcement officers to watch his home and secure him in his home 24/7. if house arrest is ordered by this honorable court as a condition of a pre-verdict bond. Mr. Williams is hiring cops to make sure he stays in his home. Oh, I'm not drinking wine. I'm doing my sugar-free Pepsi. So it's not wine. I wish I could drink. Oh, that would be glorious to have half a bottle of wine during this. That would be fun. Yeah, record label have a part of their budget to endorse politicians. So yeah, it's really hard, because if they try to go after them for rubbish, they will. The prosecution would have had phone calls from politicians. Mr. Williams will also submit to wearing an ankle monitor if ordered by this honorable court as a condition of pre-verdict bond. Mr. Williams will submit to a condition that any person who would visit him at his abode would have to be on an approved list provided to this honorable court as well as this district attorney's office. And if the individual's name is not on this list, that person will be denied entry to his home. Moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer. And if the visitor do not agree to consent to this search, the person will be prohibited from visiting with Mr. Williams. Mr. Williams also agrees that any of his text messages, telephone calls, emails, or other forms of communication in any manner can be secured, and if the information provided to this honorable court if desired, as if Mr. Williams was in custody and on a recorded line. The cost of the 24 hours, 7 days per week off-duty sworn police officer details, as well as the cost of the ankle monitor and any other related cost, would be incurred by Mr. Williams. With these parameters in mind, it cannot be said that Mr. Williams will be a threat or a danger to the community or any person or property in the community. And the Sun Council will agree to meet with Mr. Williams at his home to continue to prepare for this trial. I'm more of a beer person than a wine drinker, but I do appreciate a good wine. I actually do. Chilled, if necessary. Depending on the level of intoxication, then I won't care about the temperature. The above conditions place Mr. Williams in custody in his home. See Brown v. State. Specifically, our General Assembly have provided for the creation of electronic pre-verdict release to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pre-trial release, monitoring, and home confinement. The legislature found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Mr. Williams' home is a place where he can be confined and restricted in movement for the purpose of electronic pre-verdict release on bond. Again, Brown v. State. Ordering Mr. Williams to wear an ankle monitor and to be in total lockdown in his home is equivalent to custody and confinement, and has been deemed lawful confinement without the punishment imposed by the current county jail conditions wrongly imposed on Mr. Williams. Since May of 2022, Mr. Williams endures the torturous conditions in the county jail, to wit, 22 out of 24 hours a day locked into a small cement cell with no contact with another human being except when his counsel visits and in court proceedings. Inedible food, living in squalor-infested room, and unable to see any activity movement out of his cell's quote-unquote windows. Number 3. Mr. Williams is not a significant risk to commit a felony while out on bond. Mr. Williams is not a convicted felon. This fact alone satisfies this bond factor. Moreover, law enforcement officers executed a search warrant on or about Monday, May 9th, 2022, after the arrest of Mr. Williams on the original grand jury indictment. An incident to the search, drugs and guns was allegedly located in this home. At the time of this search, there were numerous people in Mr. Williams' home. This because others live at his home more often than Mr. Williams, who is at his home intermittently. As Mr. Williams has several homes in the Atlanta area. Thus, Mr. Williams is not a significant risk to commit a felony while out on bond, especially with the use of the security and other conditions offered above. Since Mr. Williams is not a significant risk to commit a crime, he is also not a significant threat to the community, property, or person in same. Williams v. State. 4. Mr. Williams is not a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. Mr. Williams has suggested a condition of bond that all of his calls, texts, and other means of communication ought to be monitored, save privileged communications, and additionally, he will be secured in his home when not present in court. This will prevent any possibility to intimidate a witness or otherwise obstruct the administration of justice via electronic means. In today's times, the legislature has provided that anchor monitors are a humane method of incarcerating a criminal accused without the need for punishment that is endured by languishing in county jail. See Brown v. State, Supra. This honorable court's foremost consideration with fixing the amount of bail should be the probability that Mr. Williams, if granted bond, will appear at trial. Mr. Williams is a respected, high-profile artist who has positively impacted lives of others who would otherwise never break the poverty line. Mr. Williams has made a tremendous positive impact in our community. Mr. Williams is a positive member of society. He will continue to lawfully and ethically fight these baseless charges. Governed by the above facts and law, Mr. Williams satisfies all 4 prongs of the Ayala v. State Supra test. Mr. Williams satisfies these 4 bond factors, and thus the burden of production falls onto the prosecution. And the prosecution always retains the burden of persuasion that there are no conditions of bond that can be crafted to permit Mr. Williams to be entitled to pre-verdict release whatsoever. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. Indeed, the most important element of liberty is to be free from physical detention by one's own government. Wherefore, Mr. Williams respectfully requests a reasonable bond be set by this honorable court with reasonable conditions of same. This 23rd day of July, 2024. The state has responded. Okay, let's see. Hold on here. Motion to challenge factual findings. I haven't gotten to hold on here. Do I have that? Which one is that? Have I read that one? Which one is that? Yeah, I'm going to check with... It's more that I don't seem to have... Oh, these are in response to the motion to recuse Mr. Glanville, Judge Glanville. So, okay, that I read a couple of weeks ago. Okay, so let's go right into that one. Yay! Okay. I need to show it to you as well. There it is. In the Superior Court of Fulton County, State of Georgia, State's response in opposition to Defendant Williams' motion to challenge factual findings. Following a recusal of Chief Judge Glanville, precipitated by motions from defendants Kendrick and Williams, Defendant Williams had filed a motion to challenge the factual findings made by Judge Krause in her order recusing Judge Glanville. For the reasons cited below, the state respectfully moves this court to deny the relief Defendant Williams' motion requests. In support of this motion, the state shows this honorable court as follows. Attorney Steele, or Mr. Williams by his counsel, Attorney Steele, challenged Judge Krause's finding that there was nothing wrong with the ex parte meeting. Nothing wrong at all. Which is bull crap, in my opinion. Complete and utter bull crap. A cop-out. She couldn't avoid recusing Judge Glanville, so she tried to save him by claiming there was nothing wrong with the ex parte meeting, which is complete and utter bullshit. Background. Defendants Kendrick and Williams each filed motions to recuse Chief Judge Glanville from this case. In support of their motion, each defendant submitted an affidavit or affidavits. The recusal motion was assigned to Judge Rachel Krause. On July 17th, Judge Krause ruled on the motions and entered an order containing written findings of fact and conclusion as required by Uniform Superior Court Rule 25.6. Legal authority and application of law by Judge Krause. Judge 25.6 governs the requirements for the recusal order, and the rule grants to the judge considering a motion to recuse discretion to either rule on the motion considering solely the affidavits or to convene an evidentiary hearing. This rule requires that the judge considering the motion to recuse rule on the merits of the motion and make written findings and conclusions. Judge Krause considered the motions to recuse solely on the affidavits submitted by the defendants. I'm not so sure she did. Judge Krause included in her recusal order written findings of fact and conclusion as mandated. Even when a motion to recuse has no merit, if a judge is perceived as refuting a charge of bias, the judge's action creates a basis for recusal. In your answer to the recusal, Ms. Love argued that the three prongs, wasn't met. That was her motion to Judge Krause, which was complete garbage. As everything about Prosecutor Love, everything she touches becomes garbage. Judge Krause wrote that in transferring the case to another judge for consideration, Judge Glanville necessarily determined that, quote, recusal might be authorized if the facts alleged in the motion were assumed true, and Judge Glanville, was prohibited from opposing the motion. Judge Krause agreed generally with Judge Glanville's assessment of the propriety of the ex parte meeting, but found that Judge Glanville created a basis from his recusal when they added facts, provided context, questioned by the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Judge Krause found that, quote, in presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegation, mandating his recusal. Which you, Ms. Love, opposed. Lack of authority for Williams' motion. Oh no. You see all these ... and stuff? That is Prosecutor Love. She doesn't want the entire section in. There's plenty of room. There's only 10 pages. There's plenty of room to use the actual quote. And she doesn't. And why? Because more often than not, everything she quotes, she has no basis. Defendant Williams asserts in his finding that Judge Krause made, quote, two findings that are ... erroneous in her order recusing Chief Judge Glanville. First, Defendant Williams objects to the order's reference to his recusal motion's inclusion of hyperbole. That reference to hyperbole is accurate. More importantly, the reference to hyperbole is not itself a factual finding and is not a material issue for litigation. Seriously? Jesus Christ. Second, Defendant Williams asserts that Judge Krause's finding that the hearing in chambers was not improper is, quote, wholly against the law. It is. The rules are so damn clear. They are so damn clear. That assertion is clearly incorrect. The hearing in chambers was regarding a witness immunity and compelled testimony. Such a hearing without the defense present have been held to be proper by the Supreme Court of Georgia, which ruled the defense has no standing to be present in such hearings. This is as close to a factual lie as you can get. The hearing in chambers regarding his immunity and compelled testimony, this was the ex parte meeting was about much more than that. And also, if I remember, let's see if it is the Allen v. State, King v. State, Clark v. State. I believe that such a hearing without the defense present have been held to be proper by the Supreme Court of Georgia, which ruled the defense has no standing to be present in such a hearing. Yes, but I believe in the Allen v. State, they were told about it. They knew the ex parte meeting was held because they were told by, I believe, the judge. We have held an ex parte meeting, blah, 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 blah. In this case, in the young Thug RICO trial, the judge and the prosecutor actively tried to notify the defense. They actively tried to hide the fact it ever happened from the defense. That is a clear difference between our trial and the Supreme and the Allen v. State. And in the Allen, that witness wasn't sworn in. In our case, Woody was sworn in. So there are clear differences. Conclusion: for the reasons stated above, the state moves this honorable court to deny defendant Jeffrey Williams' motion to challenge factual findings. Adrian Love. This is so stupid. This is so stupid. This is so stupid. This is utterly, utterly stupid. Okay. Oh, Jesus Christ. You know, folks, I'm going to save some for tomorrow. So, apparently, the Adrian Love doesn't have patience. So she will file throughout the week instead of waiting until Friday. So I will portion it out because I want to talk to you every day of this week. So I will get back tomorrow with more of these motions and more of the replies from the state, because Adrian Love is such a liar. She's such a bad liar as well. And it's infuriating. It is. I don't know how. I mean, I have used so much colorful words about this piece of garbage that is the prosecution's case. I've done it for over a year now, and it seems like the prosecution, they can't help themselves. They are this bad. This is the absolute peak of Adrian Love's capacity as an attorney, as a lawyer, as a person with a law degree. It's bad. It's really, really bad. Okay. I will see you back here tomorrow around the same time, 9:30 a.m. And tomorrow I will do 2 streams. One 9:30 a.m. and then I will do one in the afternoon, Eastern Standard Time as well. So we can talk to each other more. Okay? Reform convict. Love knows you should be watching. It's going to get you when you show up in court in Atlanta when I get there. Yeah, I will be in Atlanta August 14 to 15. Or I might stay there for a while if Miss Love sees me. All right, folks, that's all I have for you for now. Thank you for allowing me to do this. Thank you for being here. Thank you for contributing in the chat. Thank you so much, folks. Okay? Hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.